case on 226. The logic,
our 5 judges bench in Ratanlal Nahata said that in 226 itself the power of review is there.
Yes, but of which order? Whether if the review is there,
yes.
But if the review is rejected,
yes.
Whether the order on review should be applicable or parent order is applicable.
There, my lord, an order or an application being rejected under review under 226 is a judgment within the meaning of clause 15 of the latest patent.
Do you have,
and going by that,
do you have any authority on that? That this rejection will also
last of those is
judgment will also be a judgment within clause 15 of the latest patent.
Where the last judgment is of the 3 judges bench of Madras High Court, authored by Justice Sanjeev Banerjee. Can you have a look to this? Citation to kindly see the first paragraph. The question is framed. The moot question that arises for consideration in this reference is whether, upon a review petition being entertained in the proceeding under Article 226 and the matter being reconsidered,
yes, rejection.
Yes, I'll come to that. All these situations have been considered in the later paragraph. And the matter being reconsidered and the original order being retained, such an order is amenable to appeal. Now here the order is retained. In my case, the earlier order is retained. Then, my lord, paragraph number 2 is the questions which were referred to the bench. Now, my lord, the situations are, my lord, para 9. Generally, upon a review petition being filed, there are 3 possibilities. First, the review petition may be rejected in limine, so as to say, upon the grounds urged for review being found to be unmeritorious. In the second scenario, the grounds may be found to be worthy for the matter to be reconsidered, whereupon the matter is taken up for reconsideration immediately, or such reconsideration is postponed to a future date after taking on record the new materials which is sought to be relied upon. After reconsidering the matter by taking into account new materials cited, the court may maintain the previous order. The third scenario is where upon reconsideration of the matter, the court varies or modifies or reverses the original order. Fundamentally, when the
fall within the second category.
Yes.
No, first category. First category.
Yes, first category, unmeritorious. Fundamentally, when the court entertains the ground for review and decides to reconsider the matter, the finality of the original order is lost and the matter becomes sub judice once again. If the court entertains the writ petition and postpones the reconsideration for a future date, the original order does not vanish, but in effect it remains in suspended animation. If upon reconsideration the original order is maintained, the same revives, or if the original order is reversed, the same stands eclipsed and substituted by the order of reversal. It is equally possible that the original order is modified, etc. Then kindly take note what my learned friend is taking the ground at paragraph 11, third line. According to the writ petition, the review petition has to be seen to have been instituted under section 114 of CPC, read with order 47 thereof, and the review petition was so instituted. The writ petitioner asserts that since the order impugned in the present case maintained the original order without interfering therewith, it is the original order which stands. Now this was the submission while Miller defending the review application. Now kindly take my paragraph 23. In other words, Parliament by legislation may curb the right of appeal in certain situations where orders may previously have been amenable to an appeal, but unless it is paragraph 23. But in between various cases may have been quoted by the honorable bench. In other words, Parliament by legislation may curb the right of appeal in certain situations where orders may previously had been amenable to an appeal, but unless it expressly prohibits a class of appeals, appeals are founded exclusively on clause 15 of the latest patent, continue to remain maintainable. An example may be taken, I skip over the example, then the full bench decision of the Andhra Pradesh High Court and various courts have been noted in paragraph 24. Now kindly skip over a few paragraphs. Please come to para 40, where our Ratanlal Nahata is noted. In the 5 judges bench decision of the Calcutta High Court in Ratanlal Nahata, the court read into Article 226 itself a power of review in view of the plenary authority that such provision conferred upon a High Court. The following passage from para 58 of the report is of significance. Then para 58 is quoted. However, Article 226 of the Constitution of India having conferred a plenary power upon the High Court to exercise its jurisdiction thereunder, the power of review is implied in the said provision itself. Then please take para 48. These from petitions. Thus, even if it is accepted that nothing in the code applies to the proceeding under Article 226 of the Constitution, the power of review has to be traced to both the plenary jurisdiction conferred by Article 226 of the Constitution and the status of the High Court as of record, as recognized by Article 215 thereof. Then 50 is the caution. A word of caution needs to be added at this stage so that this judgment is not read to imply that when a prayer for review is altogether declined, such order would invariably not be appealable. It is possible that even an order of rejection to entertain the review may be construed as a judgment within the meaning of clause 15 and an appeal maintainable against the same. Here, order 47 rule 5 is overcome. Then kindly take para 52. But when the grounds of review are given credence and the matter is taken up for reconsideration, the resultant order will be appealable if the original order was amenable to an appeal. In other words, if an appeal lay from the original order, then the order passed upon review, whether maintaining the original order or tweaking it or reversing it, will also be appealable. This is because the nature of the assessment involved in an appeal pertains not only to the order but also to the considerations that go into making of the order impugned. When fresh materials is entertained, to reconsider the matter, the original considerations and the ground indicated in support of the original order lose all meaning and significance, and the subsequent order with the grounds in support thereof are what need to be assessed in appeal. Thus, upon a review being entertained, whether or not the original order is maintained or reversed or modified upon reconsideration of the matter, the resultant order has to be regarded as a judgment within the meaning of clause 15 of the latest patent in matters under Article 226.
Sir, Mr. Advocate, there is no difficulty. But what I also said at the one point of time, but the difficulty that arises is that you challenge the parent order and the appellate court has affirmed the said order by dismissing the appeal. Now, if a liberty is granted to go for a review, now question is that how far the review jurisdiction can be exercised by a court. It says that review jurisdiction not only emanates from a statutory provision but is a plenary power of the High Court so far as Article 226 are concerned that the review can be maintained. No doubt. Right. The forum is also provided that this contains a plenary power. Clause 15 is a judgment within the meaning thereof, and therefore there is no difficulty in maintaining appeal. Right. So we are not. He was taking a third point. We were not really very happy with that. Anyhow, the judgment also corroborates that there is no difficulty in maintaining an appeal. Right. And Order 47 Rule 7 would not stand as a bar in maintaining an appeal because it is not an appeal under the Code of Procedure, but it is an appeal under the latest patent. Yes. So this is how we have to pursue, no difficulty. Only thing is that if the appellate court did not interfere with the original order, and the reason has been given that why he does not want to enter into this. Once it is done, then it will tantamount to merger of that particular trial court's order into appellate court's order. Whether a review before the single bench is maintainable.
Yes.
When the order is affirmed by the division bench.
Well, first is
That order. That is what I'm asking. That once it is affirmed, it merges. Then how can you?
Whether the single bench can modify that order.
Even modify or entertain anything to be touched upon. Or I am going into the very basic one, whether the review itself is maintainable.
well, according to your lordship's prima facie view, since there was a merger, therefore there is no question of any review by the court below or the learned single judge. But please look into the order of the learned appellate court.
As seen,
Yes.
the liberty is granted to agitate the point in the review jurisdiction.
Now,
I am saying that this was unwarranted. The moment the court dismisses the appeal, then and there it becomes a functus official. He lost the sin of the matter. There was no occasion to pass a further direction conferring a particular right which is otherwise not amenable or available under the law. In a normal circumstances, if the parent order is affirmed by an appellate court, can a review be maintainable? No. Answer, I think you will also say no. If SLP is not an appeal,
SLP is not an appeal.
So it's not a question of merger and exclusivity. I can't pronounce that. It was Kamayatun or something. See, I believe
2006 SCC, I believe.
2006.
Mr. Muzumdar is very good in remembering numbers. Apart from the other good qualities that he has.
I'm also not bad. Numerical numbers are. Yes. Can the court grant that liberty?
Section 5. Milord, today, Milord, please consider, Milord, possibly subject to correction, Milord. This bench possibly cannot go into that. Otherwise, that would amount to revisiting the previous appeal court's order.
Why I said that judgment to be cited?
Please.
Praveen Pandey. In that judgment, what has happened? There was a suit filed by a judgment claiming a right of tenancy.
Appeal. Supreme Court. Appeal.
And there was a suit filed by the landlord against the tenants for eviction on the ground of subtenancy. Sorry, the suit was filed by the tenant for declaration. And suit filed by the
Subtenant for declaration of tenancy rights.
tenant for declaration that he has a right to sublet.
Acha.
And the suit was filed by the landlord for eviction on the ground of subletting. The first suit was taken up. Those were in different courts. It was decided tenancy right, subtenancy right to sublet was not held. Then at the appellate stage, an application under order 41/27 was given that in 1956 Act, there is a provision that a statutory notice, if it is given, then you cannot seek a eviction on the ground of subletting. He is a notified subtenant. This document and the reply by a landlord was also thought to be relied upon before the appellate court. The appellate court says, I am not entertaining now all these points. Order 41/27, I am not. I am dismissing it, dismissing the appeal, but giving you a liberty to go back, to rely all those documents in that suit. That will be a vital one, because
The other suit.
in that eviction suit, where if a notice is given of a subtenancy, then unless a subtenant is also made a party, the suit cannot be maintained in 1956 Act. That was the spirit of the division bench. And then gave a liberty that all these documents you will rely upon and the court will decide that. They went and relied upon those documents. The court said, I will not look into this since the appellate court rejected, did not accept this order 41 rule 27 and cited against you. So we can't. Liberty was shown that this was given and you will have to. Nothing, dismissed, appeal, appellate court held that this liberty was surpluses. Should not have been. When once you dismiss appeal and order 41 rule 27, there was no occasion to give a liberty to rely upon those documents and to consider it. The matter went to the Apex Court. Apex Court entertained the appeal, admitted the special repetitive appeal. What would be the effect of this? And ultimately, by an elaborate judgment, says that those were surpluses. Once you dismiss the appeal, you become functus officio. You can't pass any order which would really reopen or revisit, which invite a revisitation. That you cannot do. That's why I asked that particular judgment to be placed. But I'll try to find out. Here is a case which is distinguished on facts. It was your submission that I will go and agitate that point.
Right.
The court simply said that it's open to you if you are so advised. The word was, yes, you can go and do it. Yes. It is not really a conformance. So that is why, therefore, my lord, yes, the supporting counsel immediately took a third point, not entertainable.
Therefore, my lord, first, my lord, I need to satisfy your lordships that whether at all a review is maintainable after.
Absolutely. That is what is the.
Then we are on the merits of yours.
Absolutely. I'll come with that. Review is maintainable. We are not saying appeal.
Yeah, I get your lordship.
Review itself is maintainable.
Very good.
And Mr. Mujumdar's immediate junior, I don't think so. We are very satisfied.
No, of course, he will take all technical objections that he can.
But when the state takes all technical objections to deny incentive, we have to take all the technical objections to. When state takes all technical objections to deny incentive, then we have to take all the technical objections.
Well, there is no technical point at all. The first line itself is sufficient to be not throw away his writ petition. He is asking refund of tax. There is no law in our country for refund of tax. Supreme Court said that there is no promissory estoppel. There can be no enforcement of an order of refund of tax from 92.
It's true. That's on the merits.
That's on the merits. So no technicality involved.
Can you reopen that merit is a.
Yes, definitely.
Is maintainable
yes.
of the review.
I'll come back.
Of the review, then we'll consider.
Right.
And when this is an appeal arising out of a dismissal.
Order 47 rule 7 will not come into play. Will not.
Will not.
141 says that in the provision of the court relating to a suit will not be applicable in a proceeding under Article 226. Explanation is given. So that is excluded.
She is referring to
from the purview of proceedings. Because this is emanating from 226, where the plenary powers to entertain the review is in.
She is referring to section 144.
141. 141 of the code. Please read explanation.
141.
Explanation.
It will not apply to read.
This will be a judgment.
But the principles will apply, my lord. But the principles will apply.
No, the word proceeding which is appearing in the Code of Civil Procedure shall not include a proceeding under Article 226.
But in one judgment, which my junior,
these are all from civil suits.
No, one judgment which went to Supreme Court, that was an order dismissing review petition in a 226 matter. And then the Supreme Court held that no appeal would lie under Order 47 Rule 7.
I think that is a matter pertaining to a Kolkata Corporation matter.
I have the judgment.
Because I could say yes.
No, I don't think so, my lord. Subject to correction. Social finance. এটাই
কোথায় গেছে না
এটা গেছে হচ্ছে
জাজেস বেঞ্চ
Yes, I'm just checking, my lord. এটা কোথায়
নিউ দিল্লি কনজিউমার ডিসপিউটস
না একটা আছে 226 আরেকটা জাজমেন্ট আছে দাও 226 That's Justice Pasad's judgment. Justice Pasad's judgment, correct.
এটা 226 হাইকোর্টের ডিভিশন বেঞ্চ 226 থেকে আছে
But if a lordship kindly have a look at this judgment. Oh, this is a marked copy. Kindly. This is arising out of 226 only. But this was troubling me also, that whether this exclusionary clause would apply or not. This is 2007-15 SCC. यही ना ट्वीट से हुआ था ना
715 SCC पेज
पेज 370.
You have given me one more copy. তোমাকে উল্টো দিয়েছে নাকি?
I'm sorry, Malas.
15 হ্যাঁ ঠিক আছে
তোর বাড়িতে
ওটা ওনাকে দিন। কিশোর দাই দিন।
সাটা ফাটা কিচ্ছু রয়নি না অতক্ষণ আই ডিলিট করে দিয়েছি বড় মোবাইল বড় ভয় হয়ে যায়
It is a repetition. Especially rejection of repetition and rejection of the challenge together.
प्लेटफॉर्म छोड़ दिया है हां
এটা দেখাবো
কি করতে দেবে
It relied upon 1994 volume 2. Yes, you have that.
ঠিক আছে
1994 volume 2 টা দেখুন
কম করলেও বেশি লাভ হবে না
Shankar Motiram Nale. But in fact, that judgment has been relied on by the Supreme Court in
675 and 677. But this is the key judgment which is relied upon, but does not lay down in explicit terms that whether the appeal lies or not. I think this judgment, Mr. Advocate General,
yes sir
whether this Shiv-Charan Singh has been considered here, and the other judgment of the Madras High Court, and the other decisions which were relied upon. Mr. Mujumdar, I think there is an old judgment of our High Court. It is not. No, Shivdev Singh has been considered.
Shivdev Singh is that 1960s judgment.
क्वालिटी वाला सब कुछ वाला
but that is final separate
read.
if the powers are so wide that we can go for a separate read also
दिसंबर हो
So Mujumdar, there is an old judgment decision of our High Court.
But we will try to find out.
Petition.
We'll try to find out. Because I was looking for read petitions. Review arising out of read petition.
Yes, I think on read petition.
I will try to find out, Mother, definitely.
কত 18000 সাবস্ক্রাইবার ঠিক আছে
because justice bhattacharya bhaskar bhattacharya's division bench have done away with all nomenclature.
And that is Maruti Real Estate.
All nomenclature.
I told my junior that Learned Advocate General would rely on Maruti Real Estate.
There will be no period of limitation.
I know. I know.
So I appeared in that.
I know. In one matter, your lordship pointed.